Since the acronym was coined 10 years ago, the issue of forest carbon rights has always been an issue of that REDD plus or REDD plus supporters have been insisting on. Depending on your carbon trading or REDD plus implementation strategy, this question has multiple answers. Look again. Stopping deforestation and participating in REDD+, whether through results-based payment schemes, jurisdictions, or project-level REDD+, all involve understanding carbon rights. The term itself is a misnomer. This video is of our REDD+ Another Contribution series. It will propose and discuss some carbon rights related to tropical forest countries. First, the government faces the challenge of achieving national forest and climate goals, including those communicated in the nationally determined contributions under the United Nations Framework Convention on Climate Change, while recognizing the rights of communities, private landowners, and others manage or use forests. Countries consider the reduction and removal of greenhouse gas emissions in order to report on the progress or achievement of the goals in their nationally determined contributions. These targets can cover specific sectors or the entire economy. At present, 77% of the nationally contributions also consider forests determined. An open question is whether the calculation and confirmation of emission reductions under voluntary carbon market standards such as VERA's VCS should reflect in NDC, whether countries should deduct from their NDC the emission reductions transferred from private actors to actors in other countries. Although standard setters are responsible for addressing the risks of double counting and avoiding misleading claims, legal issues arise when countries decide to regulate voluntary carbon market transactions, either following the guidance of the standard or complying with the conditions established by the agreement and the donors. A solution that treats voluntary carbon market units in the same way as emissions under NDC aimed at solving the double counting of emissions reduction risks, combining private standards and international law with different stakeholders, accounting systems, carbon credit definitions and legal treatment. Transactions related to specific land and specific ecosystem services, such as voluntary carbon market transactions, are different from commitments under NDC. Such commitments cannot be traced back to the identified forest plots, nor are they related to specific activities, but are related to a combination of land use policies and private activities. The government tries to influence these activities through regulation, standards, and subsidies. Secondly, it is necessary to understand, define, and allocate carbon rights. Only a handful of countries define carbon rights according to their laws, and if so, the definition also depends on the specific circumstances. For example, in New Zealand, the forestry sector is protected by the National Emissions Trading System, and landowners can apply for the forests they have promised to protect. New Zealand units. In Guatemala, the National Climate Change Law clarifies the emissions reduction units rights. Those who invest and develop carbon market projects are relieved. If the transaction occurs under a specific policy or law, such as the New Zealand Emissions Trading System, specific rules and regulations, the value of emissions reductions or removals are based on their recognition under the system. In all other cases, including the case of Guatemala, where the law confirms pre-existing rights, the transaction is carried out in accordance with general legal principles. The different circumstances that lead to the allocation and creation of carbon rights also mean that carbon rights can, depending on the context, be limited to government permits, services, goods, or financial instruments. For the forestry sector, in almost all cases, carbon sales rights they all follow the right to manage or enjoy the benefits of land and forest properties or communities, such as wood or non-timber products. Therefore, the carbon rights related to specific ecosystem services are held by individuals, communities, subnational jurisdictions, or national governments. The extension of some land rights depends on who owns and manages the land. Unfortunately, in many countries, the rights to manage land use are at different levels and partially conflict with each other. In these cases, communities, private landowners, and companies must agreements are reached on how to share rights and responsibilities through contracts, and then projects can be developed and registered according to carbon standards. Third, due to the various customs and legal rights of local public entities, communities, and private entities that manage and use forest resources in many countries at the level, the concept of forest carbon rights is particularly complex. Conflicts and violent incidents related to land rights claims are also very frequent. Carbon rights add another layer of claims to the already disputed land claims. The most affected are indigenous peoples and local communities. Communities, they have strong historical, traditional and customary requirements for forest land, but their rights are still not fully defined and recognized. They have always been for some reason skeptical of any market-based REDD+ implementation. In this case, discussions about carbon rights often become proxy discussions about fair recognition of ancestors and current claims. This also means that carbon rights can only be clarified only by recognizing and clarifying the status of the underlying land. Although this may take several years, but it turns out that a participatory and transparent approach can now involve local communities and institutions in public plans and private projects. The Guadcarbon Forest Carbon Project in Guatemala is implemented by national park authorities and local communities, supporting the success of international organizations such as the Rainforest Alliance. The REDD+ project is a good example. Fourth, any regulation of carbon trading must be carried out within the scope of each country's constitution and legal system. One government negotiates with another government for results-based payments for REDD+ emissions reductions. Facts may stimulate the supervision of the forest and land sector, but it cannot be the basis for ignoring existing rights under national laws. Prohibiting participation in voluntary carbon market transactions requires a formal law that must pass a constitutionality test. In most cases, private property in developed countries with strong protections and other systems, any law restricting the enjoyment of such property must pass high legal barriers and be a safeguard necessary to defend the public interest. In the end, none of this answers how a country should implement REDD+. In most cases, it requires public supervision, strengthening governance, combating illegal practices, clarifying land ownership, protecting critical ecosystems, and designing national forest and land investment and community forestry plans. Integrating REDD+ projects into the national system can avoid infringement of original rights and help local participants participate in forest protection. Nested projects help to coordinate different levels of accounting in the national accounting system and can promote a more robust project baseline. In some countries, legal systems and land ownership systems may require private actors to directly participate through various incentive systems, such as voluntary carbon markets, while in other countries, the national REDD+ benefit sharing system may be the most effective way to transition to a long-term sustainable landscape. In some countries, the rights of indigenous peoples and local communities will be strengthened through contracts with the national government. In other countries, they may decide to participate in their own plans and activities. There is no single formula for REDD+ implementation, and the reliance on non-state actors will depend on each case.